I want to introduce these three and then go right into our questions. First panelist I want to introduce is Jonathan Nelson. Jonathan and his wife, Amiko, are long-term members of Fifth Avenue Presbyterian Church. Jonathan was first admitted to the bar 43 years ago in Chicago. He moved to New York in 1987 and joined Fifth Avenue Presbyterian straight away, eventually serving as both a trustee and an elder here. 25 years ago, Jonathan collaborated with a number of other people, but key among them our second panelist, Kate Pringle, to defend the church's homeless ministry in federal court, where we won and won and won and won until they gave up, right? They said, no mas. For the past 10 years, Jonathan has led a law firm that practices religion law, and that means it's very interesting if you look at Jonathan's website. A lot of his clients are religious institutions. Kate Pringle is a partner at Friedman Kaplan, where she leads the appellate and constitutional law practice group. Over the past year, she has represented the Brennan Center for Justice and legal historians in presenting to the Supreme Court historical evidence on separation of power issues. She clerked for Justice Samuel Alito when he was on the Third Circuit Court of Appeals, and she was the editor-in-chief of the Georgetown Law Journal. She has also served as a trustee and elder at Fifth Avenue Presbyterian Church. And finally, the Honorable now Sean Coffey, having been confirmed by the Senate. Sean and his wife Ann are long-term members of Fifth Avenue Presbyterian Church. Sean graduated from Annapolis and served in the Navy as an active and then reserve officer for 26 years, retiring as a Navy captain. A graduate of Georgetown Law, he practiced law here in New York for over 30 years, including several years as a federal prosecutor. He most recently served as the 24th General Counsel of the Navy in the Biden administration. He currently works as a mediator of large cases and teaches part-time law at Harvard Law School and Georgetown Law. Let's give it up for these three panelists. So to start things off, I'm wondering if each of you can describe it, and I'm going to say the word briefly a lot today because you get a pastor and three lawyers. We all like to talk. This could go on for days. Can you describe in 2 to 3 sentences what the Constitution means to you as an attorney and an American citizen? And then can you briefly tell us about the best law school class that you had on constitutional law? And Jonathan, we'll start with you.
Thanks, Scott. So from my point of view, I think really the Constitution has largely performed the role that the framers intended for it. It preserves and it shapes a political structure that up until now has been durable and that's largely democratic and tolerant in nature. So that's my brief answer. But then on law school, my best class, I think, that dealt with the Constitution was a seminar taught by Professor Michael J. Perry, in which the text was his book, The Constitution, the Courts, and Human Rights. It was an exploration of the legal, the constitutional, the moral, and the philosophical, if you will, underpinnings of the Roe v. Wade decision, and showed the strengths and the weaknesses of arguments in favor of favor of the decision and against it. And so that was really fascinating and a great introduction to constitutional law.
And where was that class at?
At the Northwestern University School of Law in Chicago.
Thank you. Kate, you're up next.
So when I look at the Constitution, one of the things that strikes me is how thin it is. It's a small document, but it really encapsulates two monumental principles. And one is the really groundbreaking and revolutionary principle that power should come from the people and not from some other source, from God, from property, from tradition. It comes from the people. And the second is the importance of compromise. And we can talk about that some more, but our nation would not exist were it not for the fact that the Constitution encapsulated and resulted from compromises, some of which seem indefensible today, but are really what brought us here as a nation. In terms of my favorite class, I had some great classes at Georgetown. I remember, in particular, a class taught by Professor Jerry Spann, where he gave us a lot of room to just debate all of the principles and the moral principles that are part of our Constitution and how they play out in cases.
Thank you. Sean?
Well, I think thinking about this question, have a personal relationship with the Constitution because by my count, I've taken an oath to support and defend it 9 times. And I took it as a 17-year-old midshipman as a plebe at the Naval Academy. Upon my commissioning as an ensign, promotion to JG, lieutenant, lieutenant commander, commander, and captain. I also took it when I became a federal prosecutor here in Manhattan, and I most recently took it when I became general counsel of the Navy in February of 2022. And, I hadn't really read it when I was 17, but I did get familiar with it over time. And I think what's really important is that the military and the prosecutors take a vow not to a party or to a politician, but to an idea on paper that reflects the things that Jonathan and Kate told us. We both went to Georgetown. I suspect you went to class a lot more than I did because I was a night student in the Navy at the time. So I took Con Law 1 and 2, which were great, but I think the course that really captured the beauty and protections of the Constitution for me was criminal procedure, because it talked about what the government can and cannot do with regard to the most heinous potentially among us, criminals, murderers. I mean, there are just things you can't do. And a quick vignette. I read Miranda versus Arizona, a case that everyone's familiar with, right? I was aide to a Republican vice president at the time, George Bush, and we were in Moscow for the funeral of Konstantin Chernenko. And around 1 o'clock in the morning, we went to the Kremlin to meet with the new leader, who was Gorbachev. And the reason it was 1 o'clock in the morning was because Bush was not a head of state. So every head of state got priority, and then it got to the number 2s. And after Mr. Bush went into the room with Mr. Gorbachev, I sat outside with the Secret Service and my KGB escort, and I did what I always did when I was outside meetings with the vice president while I was at Georgetown Law. I pulled a law book out, and it was criminal procedure, and I read Miranda versus Arizona in the Kremlin. And at one point, my KGB escort asked me what I was doing, and I explained to him Miranda versus Arizona. I said, in America, if you're arrested, you have the right to remain silent. You have the right to an attorney. If anyone violates these rules, they can't hold it against you. And I paused, and I said, how does it work over here? So the Secret Service thought that was fun. So that really brought home the Constitution and the protections for me.
Thank you. The Constitution is a document that the judicial system is constantly striving to interpret. And this is curiously one of the ways in which the work of lawyers and clergy overlaps. We are all interpreters of texts. Can each of you describe briefly what approach you take to interpreting the Constitution? And another way to put that question is, what's the relationship between this moment in time and the work of the framers? In other words, how does the Constitution, in your mind, speak to us today? And we'll start with Kate.
So I've spent the past year doing a deep dive of constitutional history through some of the work that I've been doing and working with constitutional historians. And I think we make a mistake sometimes in reviewing the Constitution in thinking we have to go back and figure out, okay, how would the framers answer this particular question? I think what's more important is understanding what were the morals, what were the words, what were the ideals that were chosen by our framers. And so I am very focused on trying to understand what was this revolutionary document and what was the future that the framers saw for us. One of the limitations of the Constitution is a lot of it was written to address a problem that is really receded today. A lot of what animated the framers was the competition between states. And a huge amount of the Constitution is devoted to this question of, Virginia competing with North Carolina, competing with Rhode Island. We don't really think in those terms today. But what we can learn is what were the values that came out of that Constitution and out of the framers' struggle to deal with those competitive instincts, with their struggle to both empower individuals to have the power to elect their representatives, but at the same time restrain the power of any individual. And so that's what sort of I think is most interesting about studying the Constitution.
Thank you. Sean.
Well, I agree with that approach. I really do. Just a historical note. Natalie talked about, and you all know we're going to have the 250th anniversary of our country this year, but it's not the 250th anniversary of the Constitution. That it wasn't ratified until 1787. And that's what we operated under before that was something called the Articles of Confederation, which really wasn't working, and which was why the framers of the Constitution worked so hard to lash the states together. There is an alternative way to look at the Constitution to what Kate described and to which I ascribe, which is what are the values from that document and how they apply today, and that's the original intent. That there's a very significant school of thought that influences, I think, your old boss, Sam Alito, and others, that you should say, what would the framers say? And it's legitimate. It's serious school of thought. I disagree with that school of thought because I think trying to divine what people who either owned slaves or tolerated slavery would not allow women to vote. They were terrific people for their day. But I don't think addressing legal issues today through those eyes is appropriate. But that said, they gave us a wonderful document. It is a document of compromise. It disperses power. It's somewhat of a reflection of having been colonies under a king. It's imperfect, but it has an amendment process, and it's been amended, and perhaps I'm sure will be amended again in the future.
I'm going to go to Jonathan, but I want to just throw out a follow-up question just listening to you, because one of the things that preachers are sometimes accused of is sort of cherry picking from Scripture the things that make their case. Does the same thing happen in constitutional law? And I'll go to you, Jonathan.
Well, for sure it does. Now, as I'm always representing private individuals and institutions, and if the Constitution is involved, then the person on the other side is usually a government. So I'm always starting with rights that have been they're written in the Constitution, usually in the Bill of Rights, especially in the First Amendment. But then they've been interpreted by hundreds of years, or at least many years of judicial interpretation. So there's a gloss on that, and you read what has been said by other courts in similar situations, and you, to the extent you can, you try to fit your situation into it, and to the extent that it doesn't fit your situation, you try to distinguish it or argue it on the basis of either an original intent or some kind of historical argument. And in a recent case involving parochial school funding, in 2020, in Espinoza versus the Montana Department of Revenue, the court did a very interesting thing. They overturned a Montana state law principle in their constitution, which is based upon something called a Blaine Amendment, which is a type of law that prohibits government aid to parochial institutions or to any kind of aid to religion. And the court overturned the Montana application of that, saying that the Blaine amendments and the whole Blaine Amendment sort of movement in the 1870s was anti-parochial. It was anti-religious. It was particularly anti-Catholic. And so all of those laws, all of that kind of legislation and constitution writing that was done during that period of time and shortly afterward has been poisoned in a way by a kind of anti-clerical bias, and particularly a historical anti-Catholic bias. the historical research that went into that established that prior to the immigration of Catholics in the middle of the 19th century, there had actually been a substantial amount of permitted government subsidy of education, private education, any kind of education that was done, whether it was parochial or not. So that was that ended up in now in our Supreme Court interpretation of how do you go about looking at the application now of these constitutional principles. In this case, the anti-establishment clause in the First Amendment, in light of the precedent that you have. Up until the Espinoza case, the courts had been gradually eroding some opposition to the use of public funds for religious uses, but they haven't made this kind of a declaration. So that's not very unbrief answer.
No, but it's interesting to see how the interpretation continues to evolve and what sort of things historically they bring back in. So it's not just from the framers, but it's also why was this particular law put into place in the first place. I have a few targeted questions, one for each of the three of you. The first one goes to you, Sean. Sean, you're currently teaching a class at Harvard Law School on military issues in the law, or as you put it to me earlier, lawyering at the Pentagon. One of the things that has been bandied about in recent months, and this comes again from both the right and the left, but is focused on the current administration, has to do with our activities in Venezuela and perhaps now Iran. Should they have been approved by Congress? Can you speak about the legal issues involved in the president's use of the military, both abroad and then in this country against our own citizens?
In 2 or 3 sentences.
Yes.
Wow.
And make us laugh.
Well, it's true that, the Constitution established a disbursement of power over the military. Article 1, and Article 1 it's important that you note that Article 1 is about the Congress, about power to the people. Article 1 gave Congress the power to declare war, not the president. And it also controls the purse strings to approve the funds, and that's a way of controlling and providing oversight as well. Article 2 is where the president was designated as the commander-in-chief. And if all you do is Article 1 and Article 2, what you would come away with is Congress decides whether to go to war, and the president decides how to execute that. But it's much more complicated than that because of the evolution over time. We're no longer responding to attack that may be coming by, masted ships sailing from Europe. I mean, we have minutes to decide sometimes. And so both parties have gone along with the evolution of increased authority for the president. And there are things like the War Powers Resolution of 1973, where with regard to what had been happening in Vietnam, there was an attempt to say to the president, hey, you have to consult with us before you use force. And if you can't do it, you have to tell us within 48 hours of doing it. And if you don't if we don't approve it, you have to get out in 60 days, maybe 90 days, under some circumstances. And then after 9/11, you had the authorization for the use of military force against Al-Qaeda, against anyone who did 9/11 and who helped them. And that's been stretched by every president, including, as recently as Obama before Trump and Biden as well. And none of those applied to what was going on in Venezuela. If I could just divide Venezuela into 2 pieces, there's the targeting of boats in the Caribbean and Eastern Pacific, and then there was the Maduro extraction. The latter, I think, is a close call. In fact, last week, in the first week of our course with these very, very bright Harvard Law students, we broke them into 2 teams. The blue team had to defend the Maduro extraction as legal. the red team had to explain why it was legal. And it's a very, very close call, I must say. Not so close on what's going on with the extrajudicial killing of folks on these boats. There's been real consternation within the military about whether these strikes are legal. You may recall that the commander, a 4-star admiral, a fellow Annapolis graduate, retired precipitously after a meeting at the Pentagon with the Secretary of Defense about what they were planning on doing. And reportedly, the senior military lawyer for that combatant commander had expressed concerns about the legality of it. The admiral shared those with the secretary and was given apparently 15 minutes to change his mind, and he decided to retire. So there's some real issues there. And I just put a marker down. The first strike, the one we've all heard about, the double tap, where they blew up the boat with 11 people on it and then came back around and then did a second strike to kill the 2 survivors. When the facts come out about that, as somebody who flew counter-narcotics missions for the Navy over the Caribbean and was briefed on what to look for, the notion that a boat running narcotics has 11 people on it, I'm very skeptical, because every person on that craft takes the place of, say, 200 or 100 kilos of cocaine. That doesn't make economic sense. So I think there's more to come out about that. But I think there are a lot of folks very troubled by the Operation Southern Spear is what it's called, the counter-narcotics piece. There's more debate, legitimate debate about the Maduro extraction because it was limited. And the fig leaf is it was military support for a law enforcement operation. So at least there was an effort. I've read the OLC opinion, Office of Legal Counsel opinion, the parts that weren't redacted, so it was a very short read. And it was thin, but it was at least an effort to paper it over as legal.
Okay. Thank you. Thank you very much. Kate, you've been involved in conversations between lawyers and business leaders strategizing on responses should immigration enforcement officers descend on New York in a similar manner to which they've descended on Chicago and Minneapolis. Can you talk a bit about what you see as the constitutional issues related to ICE's practices and behaviors?
Yeah, nothing lays bare the fragility of some of our constitutional rights as what we see right now in Minneapolis. We have become accustomed to the protections of the First and Fourth Amendment, and those are being breached in a shocking way in Minneapolis. So let me just speak to those in turn. The First Amendment guarantees your right of assembly and of speech. But in Minneapolis, protesters are being directly attacked. And they're being, we've all seen the footage. They're being pepper sprayed in the face. They're being, pushed and shoved and subjected to danger. And what I think people don't realize is how fragile those rights are. If you are attacked in Minneapolis right now, or anywhere, when they come to New York, and they will, if you are attacked as a peaceful demonstrator, you have no recompense. You have no right. The good children who have lost their mother and do not have a source of income cannot sue. And we assume that we have the right to redress abuses, but we don't necessarily. And so it is a very fragile right. The other right that's significantly at issue is the Fourth Amendment. We understand from the Fourth Amendment that unreasonable searches and seizures are prohibited. But right now, the ICE takes the position that they can and will walk up to anyone, and let's be honest, we're not talking about anyone, we're talking about brown and black people. And that they have the right to walk up to anyone who looks to them like a non-citizen and say, where are your papers? And if you don't hand them over, I'm putting you in the car and you're going to be arrested. And more recently, they've taken the position that they have the right to break down doors to come into your home if they believe that a non-citizen is in the home that they need to take into custody. And that is contrary to my understanding of the Fourth Amendment, but the Fourth Amendment doesn't define what an unreasonable search and seizure is. That gets defined through court cases, and the court cases haven't reached these issues yet. So again, terribly fragile. I'll just point out one other thing about Minnesota that really scares me, and it's going to scare me in every part of the country, that we are combining an increasingly aggressive paramilitary force with a heavily armed country that has been taught to stand their ground. And that is inevitably going to lead to death and violence. We've already seen, 3 people have been killed in Minnesota this year, 2 of them by ICE. And there will be more violence. And so I think it is so incumbent on all of us to be prepared, as the people of Minnesota have done, to stand up for our rights and to peacefully protest and to stand together, because our constitutional rights are not self-executing. They only protect us if we stand up for them. And so it's so important that people, that churches, that institutions, that business leaders, that all of us stand up and recognize that we are each protected by the Constitution, and we are each threatened if our fellow community members are violated.
Thank you, Kate. Told you this was going to be good. Jonathan, your practice focuses on representing religious institutions, trying to secure First Amendment rights for religious communities. What constitutional issues do you see arising out of this moment in history? And what do you think the significance is of the Trump administration declaring that ICE is permitted to enter American churches in pursuit of people whom they are seeking to detain?
So there are so many things one could raise. One of the, I think, key constitutional problems that we see in the current moment is the situation that comes out of the Supreme Court's decision or decisions, it's a line of them, that money is equivalent to political speech, and that congressional limitations on the expenditure of funds in support of a campaign are basically not limited by, the Congress doesn't have the right in many respects to regulate that, because it's political speech and protected by the First Amendment speech clause. The result of that has been the inflow of billions of dollars into our political campaigns, and a complete restructuring of the way that we get information and form opinions. It's poisoned our body politic, and that's a constitutional problem that comes out of the interpretation of the First Amendment. From the standpoint of government practice, I join with Kate. I think that the fact that the government at the present time seems to have a disdain for the Constitution, basically, is the greatest concern perhaps that we have that's constitutional in nature. Our Constitution is one of limited power. Our Constitution is one of divided power. And it's a federal Constitution, so that there's a respect of the federal government for the 50 states that make up our federation, our union. And all of that has been sort of plowed under by an administration that is determined to increase federal executive power in every way possible, and to limit anything that could stand in its way. At least that's my perception, and that's a constitutional problem that doesn't relate to the specific provisions of the Constitution, but to the entire nature of constitutional government in the United States of America. There is also, going with that, a disdain for civil rights of immigrants, first of all, but then also of non-supporters. There is
there's a strain of the support for the current administration which calls itself Christian nationalism. And to the extent that people use that phrase, of course, I don't think it's accurate, but there are people who are using the traditional Christian sort of majority interpretation of history to say that this is what America should be like, and therefore if you don't fit into our interpretation of the way that America should be run, you're anti-Christian and you're anti-nationalist. And that's becoming a problem when we see things like the administration's September 25 memo on countering domestic terrorism, which asserted that domestic terrorists are organizing a violent assault against democratic institutions animated by anti-Americanism, anti-capitalism, and anti-Christianity, support for the overthrow of the U.S. government, extremism on migration, race, and gender. Now, our Presbyterian Church has positions on migration, race, and gender, and in many respects, the positions that our church takes are counter to the position that the current executive is taking, and so they might regard these kinds of positions as being, using their term, domestic terrorism. And that kind of goes back to the practice that we see in the field of pastors getting shot, basically, not yet with metal bullets, but on September 10, Reverend David Black of the First Presbyterian Church of Chicago was shot in the head with a pepper ball, and I think you've all seen that photograph. On October 23.
Did you know that he is a former intern of Fifth Avenue Presbyterian Church?
No. I didn't remember that at all. Oh, my goodness. Though that strikes home. On October 23, Reverend Jorge Bautista of the United Church of Christ was shot in the head with a projectile by ICE at point-blank range in Oakland, California. And again, there are photos of that on the internet. These deliberate assaults on pastors wearing their pastoral clothing seems to show hostility on the part of the people whom the government is employing toward churches that they perceive as opposition leadership. Now, there are lots of other concerns that I think we all have about the current constitutional situation, but those are a couple that I perceive.
Can I?
Yeah, absolutely.
2 quick points in response to that. First, when it comes to Christian nationalism, I think it's hard to square how that's being used and what they are doing with the readings we had in today's service. Yeah. From Deuteronomy and Romans. I think it is hard. The second point, and this is the thing that really has me most concerned. I'm concerned about what's going on at the Pentagon, having spent so many years in uniform and then as a top lawyer there. But I'm really concerned about DOJ, the Department of Justice, where I spent several years in the 90s. That has become essentially a private law firm. And Jonathan, you mentioned about going after the disfavored. Just the rank corruption of the president telling his DOJ to indict Jim Comey, to indict Tish James, to go after his enemies, and to purge the FBI, to purge the Justice Department of people who were assigned to the prosecutive investigations of the president when over Mar-a-Lago and the classified documents, and over January 6th. I was at an event a few months ago. It was a year ago. No, it was a few months ago with a former Navy SEAL who was an FBI agent. And he was based in Chicago, and he told me he was about to leave the FBI. And I said, why? He goes, I'm on a list. I said, what list? Even though he was in Chicago, at one point he was put on a task force to go execute a search warrant of a January 6th defendant. He did his job. He was assigned, he went out, they did the search, they got the stuff. But because he touched January 6th, he's on a list where it's been made clear he won't have the same opportunity for promotion. And so many outstanding prosecutors are leaving because because they don't think they can comply with their ethical obligations. And the last point I'll make, and this is more than two, I'm sorry, but Trump issued an executive order last September, I believe it was, that declared to everyone in the government, every lawyer in the federal government, that his interpretation of the law or the interpretation of law by the Attorney General at his designation, that interpretation is binding, and you're not permitted to push back on it. And that's breathtaking. It's a recipe for bad decisions. I mean, policy-wise, it's breathtaking, but it is part of this overall pattern, I would say, that is utterly inconsistent with the Constitution, which is about compromise, et cetera. There's an effort to intimidate the gatekeepers. You see it with suing the media, with intimidating some of the most powerful law firms in the country, shame on them, going after academia, firing the top uniformed lawyers in the JAG, in the military within a week of taking over as Secretary of Defense, threatening to recall a senator because he said something they were unhappy about, Senator Kelly. So there's a real pattern here of seeking to intimidate and using the Department of Justice as their shock troops. That's what really, really concerns me.
How many of you remember Aram Bai? She was, for a season, our wonderful director of Children and Family Ministries. Then she went on to be a pastor in Charlottesville. And while she was down in Virginia, she got married to an FBI guy, of all things. I heard from Aram last week. She liked last week's sermon, and she said, I want you to know how important it is what Fifth Avenue is doing. My husband was on that list and he was fired because he touched January 6th. And so this is not a small issue. This is a great segue, and maybe you've hit on a lot of the points already, Sean. My next question really has to do with intimidation. Educational institutions, law firms, corporations, many have refused to criticize or push back against the current administration, citing repercussions and score settling tactics. Personally, I'm a Calvinist, so I should know better, but I've been shocked by the number of corporate leaders regularly making their way to Mar-a-Lago to do obeisance. What parts of the Constitution do you think are being infringed on through the intimidation that's currently underway? Kate, I'll go to you.
Well, there's certainly a First Amendment issue with the right of association, and that's something that I've been working with some law firms, and that's something that the law firms have asserted successfully, that you can't retaliate against law firms because you're retaliating against clients and their right to choose lawyers. But, it also largely speaks to a silence in the Constitution. The Constitution it empowers the president, but it also leaves him a lot of discretion. And the framers of the Constitution were working with their presumed president, George Washington, for whom they had tremendous esteem. And that esteem really shaped the way that they designed Article 2 of the Constitution, which is what talks about the president's powers. And we as a nation and as lawyers have really not answered the question of whether the president is entitled to use his power through retribution or for purposes of retribution. So just to give one example, the president has the power to veto acts of Congress. The president recently used that power to veto a popularly passed law that would have funded a water project in Colorado. And it's widely expected and understood, although it's not proved, but it's widely understood that the president did that because he's angry about issues in Colorado relating to the 2020 election. So it raises a real constitutional question. president has that power, is he able to use that power for purely retribution purposes? When we have a national emergency, will the president be able to say, I will award emergency funds to those states that voted for me, but not those states that did not vote for me? That is not a question that our Constitution speaks to clearly. But it is, I think, a very central question that this administration is posing and that the Supreme Court will ultimately have to answer. And it's not a comfortable question for us, but we are going to have to think about how to restrain our president so that, and perhaps our Congress too, so that we begin to treat Americans individually and not as just the party that they belong to, and that we restrain this natural inclination to take retributive actions against our enemies.
Yeah, if I may. So with regard to those powers, there was an expectation that there would be some restraint and that there would not be a scoundrel in place. But it reminds me of a big miss in the Constitution, which is the pardon power. Yeah. It really was the one thing that a king can do that was adopted, and I think they probably had George Washington in mind. And I mean, there is so much that shocks the conscience, but we're sort of exhausted. It's inundated. We're inured to it. We're conditioned to it. But the corruption that's going on with pardons is shocking. And if any of you follow Liz Oyer, the former pardon attorney, on Instagram, she regularly throwing out examples of big contributions being made, and then or letters. I mean, it's hard. Even those who support what's going on in Operation Southern Spear, and I have some classmates who are in that camp, I say to how do you square this national emergency, got to cut down the drug running, with the pardoning of the former Honduran president who was convicted in a case where the evidence showed that he was party to bringing 400 tons of cocaine into this country. Apparently it's because he wrote a letter and Roger Stone handed it to President Trump, and they played upon, I was a victim of the Biden administration like you were, et cetera, et cetera. So, if there's going to be an amendment, there's probably a long list of amendments. On that list would be something to have some sort of review or limit on the pardon power.
I'll tell you just this tiniest vignette. I mean, I get all kinds of unhealthy letters. But one of the new types that I've been getting is there are people that know that I once met with Trump who are asking me to talk to him about getting them a pardon.
Wow.
It's very, I mean, yeah, I've got a file. I haven't really done anything yet. Jonathan, where are you in all this?
So, reflecting upon the immense power that the current administration has to wreak havoc upon the lives of private law firms, institutions, to deny, certain kinds of approvals, it really seems like it's even if the things that they are doing are not directly in violation of any particular provision of the Constitution. They are in violation of much of the entire spirit of the Constitution. And so there is a concept of a penumbra, which comes from Roe v. Wade and Griswold versus Connecticut and the other decisions that have to do with individual rights. There is a spirit of the Constitution, which is a spirit that is one of freedom for the citizens and for the people who are living in the United States. There is an expectation that we have of freedom. With that expectation, of course, also goes the opportunity to, or perhaps the duty, to exercise that freedom. And the people who've given in the people who've made deals in order to prevent themselves from being subject to the immense power of the federal government, have chosen not to assert their freedoms, not to resist the encroachment of those freedoms. And of course, that's a thing that is dangerous to all of us. It is a choice, though, that each of us needs to make at some point, to the extent that any of these freedoms that we seek to exercise are threatened by the immense power of the federal government, which could, which potentially could plow any one of us under, and to do so rapidly. It brings to mind that famous quote from Franklin after the Constitutional Convention was concluded and we'd chosen a constitution. Somebody said, and I don't have the exact quote, but that's a lovely constitution you have there. And Franklin said, yes, if you can keep it. And we are at a stage now where we are learning whether or not we're going to be able to keep our constitution. One particular provision of the Constitution, which does seem to be at play here, is the requirement of the president to execute faithfully the laws. I don't think that's what's happening now. And the constitutional cure for this is impeachment.
In the Presbyterian Church, one of the things that I've noticed is that when we get into a state of crisis around an issue or a set of issues, oftentimes the place that ends up sorting us out is our judicial system. We have these, you participated in that some, Jonathan, I know. I mean, the permanent judicial councils and committees that are at the presbytery level and the synod level and at the General Assembly level. And that often ends up, it's when we're in a big crisis, those are the places that sort of have sorted us out. I think it's very interesting that right now you've got the protests in Minneapolis, and then you've got a lot of people looking to the legal community to save our bacon right now. And so I'd love for you to talk about, am I right about that? Because that seems when there's so much power vested in one area, how do you sensibly get things back on track?
Which brings us to Article 3 of the Constitution, which is the judicial branch. I think we're going to get around to it later, what gives you hope. I've been saying for a year, I think the courts will save us, but in light of what's gone on the last few months with the No Kings and the last few weeks with Minneapolis, I think the people will save us. But in the federal judiciary, when you are nominated by the president and confirmed by the Senate, you sit for life. You are no longer subject to an election or you can be subject to recall or impeachment but it's very, very rare. It's usually for corruption or something like that. Although there has been noises about trying to impeach some of the judges who have issued have ruled against Trump. But I think what you're seeing is a lot of judges, including Trump-appointed judges, are saying, no, this is not right. And it takes time. Litigation takes time. It's expensive. It's a lot of the major players who would normally be bringing these cases are on the bench because they cut deals. You need firms like Friedman Kaplan and
No, we did not cut deals.
I know you didn't. You need firms like Friedman Kaplan that are out there fighting the good fight and litigating. And I just want to do a shout out to Jenner and Block and Perkins Coie and Sussman Godfrey, and who's the fourth firm that they sued. They said, no, we're not going to cut a deal, and they won quickly in court. So I do think the courts will save us to a point. I'm not so sure about the Supreme Court, particularly a court that completely inconsistent with the spirit of the Constitution, gave the president basically absolute immunity for anything he does while in office. And don't think that Donald Trump isn't aware of that. And so, I think that it'll be very interesting to see what this Supreme Court does with the tariff question.
Yep.
Seems pretty crystal clear to me that that's a power that's given to Congress, and now Congress can delegate it, and the argument is that they did delegate it when they passed this act that empowered the president to impose tariffs in an emergency. And I think, the lower courts have seen that that's been abused and doesn't stand. And based on the oral argument in the Supreme Court, it looks like they may lose. But will this Supreme Court finally act to start trimming the sails of this executive, to be determined?
Yeah, and I think one of the problems with the current Supreme Court is that the lifetime tenure and the limited number of Supreme Court justices has allowed people to shape their cases. I mean, it's a very odd artifact that we have so much power vested in 9 individuals who are there just by, virtue of happenstance of when the last guy died. So it really, I think, is an area where we should, looking forward, consider reforms, consider a larger number of justices. There's nothing in the Supreme Court that sets the number of justices. Rotating panels so that you're not pitching your case to the, if people who do appellate litigation spend an enormous time trying to figure out which case can I craft to appeal to this justice and to get this justice on board with my argument. If we had a larger Supreme Court where you couldn't predict which panel you were going to have, you could get rid of that. There are things that we can do, but we need to really protect our judiciary, and we need to protect those prosecutors who are resigning and who have been doing such enormously important work. So pay attention to what's happening at the Department of Justice. Pay attention to what's going to happen to the judges who are willing to stand up, because they really are on the front lines of this.
Well, looking at Article 2 and politics, it looks like, because as a result of all of the demonstrating and all of the resistance that we've seen in Minneapolis and other places, and in particular because of the murders that ICE people have committed, that politically some of the people who have been lined up with the administration, particularly on the Republican side, have begun to break away. There is starting, it looks like there is starting to be a breaking up of the ice jam, if you will, in the legislature, and there may be a possibility that the legislature may begin to take action that will, in some ways, rein in the powers of the executive branch. Also, from a political standpoint, and again, this isn't constitutionally oriented, but the question is, how do we get the Constitution back on track again? Many people think that all of the mishigas that is going on in Washington and the destruction of our international relations with the entire world, the destruction of our economic policy, the tariffs, the bombings are intended as a distraction from what might be a direct personal threat to the person who's currently the chief executive in the Epstein files. And it may very well be that some solution to our constitutional problem lies in those files.
So I'm gonna go to my final question here, which you've all already and throughout have actually touched on. But I'm going to try to spin this in a personal way. Okay. Where do you find solid ground to stand on, and a place from which to hope right now? And hope gets. Somebody recently said to me, "Okay, fine, Pastor, you hope. we need a plan. And I'm like, I get that, but you do not plan well without hope. And so talk to me about where you find hope right now. And I want to make a comment. I have never seen one of these panel discussions here where like nobody's left. You're hardly even moving.
Somebody said ice was downstairs, so everyone stayed.
We have a written protocol for that.
Good.
This is not a public space.
Well, I'll start. I have great faith in the United States of America. I wore its uniform for 30 years. I'm the son of immigrants and dearly, dearly love this country. And it's not perfect, far from it, but to quote Martin Luther King, the arc of history is long, but it bends towards justice. I think the arc of our country's history is long, and I think in fits and starts, we're trying to get there. So again, I think the courts will be helpful, but at the end of the day, it's people. I've been to both No King's protests. I'm inspired by the people of Minneapolis. The recent elections, even see what happened yesterday in Texas, shocking swing there in a vote. Gerrymandering is going to probably inhibit a significant blue wave in November, but I don't know. We'll see, and I think even the Senate might be in play. And but at the end of the day, people, we're stronger. This is a real stress test for the United States of America, and I think we're going to pass. Then we're going to have a lot of damage to repair. I'm a national security buff, and the repairs we're going to have to do with our NATO allies is really, really, really significant. But I think we're going to come through this. I have great faith in the resilience of the American people, and so I'm hopeful.
Kate?
I think this is what gives me hope, which is the religious community, and that's not just churches, that's all religious people across all of the different many ways in which we all express our faith. We have been here before as a country, and that was in the civil rights movement. And we should never forget how significant it was that we had a country that regularly trampled on the rights of a massive amount of our population and tortured and abused people. And we got through it in large part because of the leadership of people calling upon their faith. And I've seen that in action. I've been involved for more than a decade with Bread for the World, and I know a lot of people here are involved in that organization as well. And I've seen the power of using faith principles to reach different people. And I really, truly believe that from all political perspectives, there are people of goodwill who care about their fellow man and who care about God's love for his children playing through our country. And so I do believe that with the leadership of people like you and our churches and synagogues and mosques, that we can get through this. It's not going to be easy, but we've done it before, and I do believe we will do it again.
I want to echo what Kate said. And, the initial language in the Declaration of Independence, and I'm not proposing revolution here, but talks about when in the course of human events something comes to pass. The civil rights movement was a human event in which it wasn't so much, of course, the religious leaders were extremely important in that. The religious communities were very important, but so were the events. Yeah. We saw on television, we saw children being mowed over by, water hoses, very powerful ones in the South. We saw people being beaten on a bridge. We saw people standing up for rights without being violent, but suffering violence because of their humanity, because they were asserting we are entitled to dignity and respect and treatment as full human beings. And we are seeing the same thing now, vividly. We are having a reenactment, if you will, of the kinds of events that led to the success of the civil rights movements in the 1960s. And, you know, we've had a lot of contested perceptions about lots of different kinds of issues that are political, but also that have very strong religious ramifications. One of the key ones being the perception about the role of immigrants in American life. And this is something that has gone back and forth for centuries in America. There have been periods of strong pro-immigration sentiment, and also, you know, in reaction, periods of strong anti-immigration sentiment. We are, I think, at a point now where it's tipping again. We're seeing the terrible, cruel treatment being inflicted upon our immigrant neighbors. And we're reflecting in churches around the country about Jesus' admonition to, you know, care for your neighbor. We're around the country looking at, in Jewish and in Christian places of worship, the need to care for the stranger or alien, as spoken in today's scripture, the widow and the orphan. And the events that we're seeing, I think, are bringing these scriptures into our hearts and into our minds and into our commitments that we're going to make this a better place. So that's one place that I see hope. I think that what we're seeing is not sustainable for the anti-immigrant, for the anti-democratic, low D democratic, for the for the people who want to consolidate power in one person at the head of one branch of the government. I think that's failing because of what we're seeing and what's happening today. I see hope in that.
Friends, let's give it up for Jonathan, Kate, and Sean. Bless you. Thank you. Safe travels. Godspeed.